How many of you know about the Johnson Amendment? Because if you've ever donated to a church or other charity, you've been impacted by it. This limitation on freedom of speech has been in effect for over 70 years. Now, the House of Representatives is trying to remedy this infringement. So we'll look at this next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach your rising generation to be free. I'm glad you could join me today. I was a deacon at a church many years ago, and I, at that time, got involved with the finances, which led me to the Johnson Amendment. So I've been fairly familiar with this particular piece of legislation for quite a while. So when I saw this legislation coming up in the House, I thought it was worth working on. Now, if you want to see my references, the text article is at the website, constitutionstudy.com. You can find the links there. But I'll talk more about the website and some other things at the end of the program. For now, let's talk about this attack on the Johnson Amendment. To understand what the House of Representatives is trying to do, we have to go back to the beginning and to one Lyndon Baines Johnson. In 1954, incumbent Lyndon Johnson was running for re-election to the United States Senate against Texas State Senator Dudley Dougherty. At the time, Johnson seemed to be in a comfortable lead in the polls. Comfortable, that is, until a couple of nonprofit organizations backed by extremely powerful leaders stepped in. H.L. Hunt had created an organization called Facts Forum in 1951, and Frank Gannett had created the Committee for Constitutional Government back in 1935. Both of these groups were anti-communist and supporting Dougherty in the race for the United States Senate seat. Concerned that Johnson was soft on communism, both of these organizations passed out thousands of pieces of literature in opposition to Johnson's campaign. When these actions started seriously hurting Johnson's campaign, he sought ways to silence them. Try as he might, Johnson could not find a law that these organizations were breaking. On July 2, 1954, Johnson presented an amendment to a pending tax overhaul bill. The amendment passed on a unanimous voice vote. The bill was passed and signed into law by President Eisenhower on August 16, 1954. There were no committee hearings or legislative analysis on the amendment, just a rushed vote. In an interview years later, a staff member stated that Johnson never had churches in mind for the amendment. There was nothing any church had done to warrant this restriction, but they got caught up in this amendment because their tax-exempt status is codified in the same section of the law. Now, according to Johnson's staffer, this amendment had nothing to do with separation of church and state. However, it has been used for decades as a threat to keep churches and ministers from engaging in public debates about so-called political issues. Let's start with the law regarding tax exemptions, Title 26, Section 501A. An organization described in subsection C or D or Section 401A shall be exempt from taxation under this subtitle unless such exemption is denied under Sections 502 or 503. We start with three sections of the law that will describe tax-exempt organizations. That is, unless they are denied exemption under Sections 502 or 503. Now, this includes the most well-known section of the tax law, Section 502c3. The following organizations are referred to in subsection: corporations in any community chest, fund, or foundation organized and operated exclusively for religious, charitable, scientific, testing for public safety, literary, or educational purposes, or to foster national or international amateur sports competitions, but only if no part of its activities involve the provision of athletic facilities or equipment, or for the prevention of cruelty to children or animals. While there are several types of organizations and several purposes that would make them tax exempt, the two most commonly used are religious and charitable organizations. I'm sure most people have a basic understanding of what a religious or charitable organization is, but we're dealing with the law and details matter. This is where the Johnson Amendment comes into play. No substantial part of the activities of which is carrying on propaganda or otherwise attempting to influence legislation except as otherwise provided in subsection H, and which does not participate in or intervene in, including the publishing or distributing of statements, any political campaign on behalf of or in opposition to any candidate for public office. You can be a religious or charitable organization, but if you want your tax-exempt status, you had better not participate in any political campaign, either for or against a candidate. Do you see what Johnson was doing? His campaign was being beat up by charitable organizations, so he used his considerable power as a United States Senator to stop it. Oh yeah, and you had better not try to influence any legislation, or your tax-exempt status would be on the chopping block as well. Notice, this language doesn't prohibit religious or charitable organizations from participating in campaigns or influencing legislation. It only threatens them with the removal of their tax-exempt status. But there's more. See, most organizations I've talked to where this topic comes up believe that the mere mention of a candidate or legislation would threaten their status. And the law says they cannot use a substantial part of the activities they perform for this purpose. Such is the state of misunderstanding of the Johnson Amendment. Enter the 119th Congress and the Free Speech Fairness Act. The specified goal of this act is allowing 501c3 organizations to make statements relating to political campaign in ordinary course of carrying out its tax-exempt purpose. Isn't this nice? Congress wants to allow 501c3 organizations to exercise their free speech rights. Maybe that title is just poorly worded. Maybe the language of the legislation will be better. In general, for purposes of subsection C3 and sections 170C2, 2055, 2106, 2522, and 4955, an organization shall not fail to be treated as an organized and operated exclusively for a purpose described in subsection C3, nor shall it be deemed to have participated in or intervened in any political campaign on behalf of or in opposition to any candidate for public office solely because of the content of any statement which, A, is made in the ordinary course of the organization's regular and customary activities in carrying out its exempt purpose, and B, results in the organization's incurring not more than a de minimis incremental expense. Should this legislation pass both houses of Congress and be signed by the President, we will trade one somewhat vague standard for another. Don't get me wrong, I love the idea of Congress no longer trying to use the threat of revoking tax-exempt status because one senator was getting beat up by a couple of charitable organizations. But I think this could be better. For example, the current standard for a religious or charitable organization to express their opinions about legislation or candidates is no substantial part of their activities. Tell me, what constitutes a substantial part of activities? Is it the amount of time spent, the amount of money spent, or just what some bureaucrat thinks is advantageous at the time? This gets replaced by the ordinary course of the organization's regular and customary activities. What are the ordinary course of activities for a religious organization? And who decides what is ordinary and what isn't? A minister speaking from a pulpit seems like an ordinary activity to me, but what if that same minister speaks at a rally or legislative committee hearing? If a charitable organization serves meals in a building they own or rent, that seems like an ordinary activity, but what if they do so in a public park? Then there's a question of de minimis incremental expenses. This is a legal term for something so small the law doesn't care about it. For example, in a $1 million deal, a $10 mistake is considered de minimis. So what is a de minimis incremental expense? Is it 1% of the organization's budget or 10? Is it $100 or $1 million? Once again, it appears Congress wants to pass a vague law and let the executive bureaucracy fill in the blanks. And we've seen how that's worked over the years. The Johnson Amendment is the very definition of arbitrary and capricious. It was introduced by a United States Senator to protect his own re-election campaign. It was targeted not only at nonprofit organizations, some of whom were impacting Johnson's campaign, but at religious and other organizations. And the language was so vague as to have allowed decades of churches, charities, libraries, and educational nonprofits to work in fear that simply saying the wrong thing could not only deprive them of their tax-exempt status, but the donations that are frequently given because of that status. That alone should be sufficient reason to simply rescind the amendment. And why should an organization not be allowed to speak their position on a piece of legislation or a candidate as a condition of their tax-exempt status? Should a group of people peaceably assembled for religious or charitable purposes not be allowed to speak on topics of public interest? Interestingly enough, to my knowledge, the Johnson Amendment has never been challenged in court. I've even heard of organizations that encourage ministers to preach on the subject of candidates and legislation for the specific purpose of filing a complaint with the IRS. Why would someone do this? Because they believe the Johnson Amendment would not survive a First Amendment challenge in federal court. These organizations hope that the IRS would threaten their tax-exempt status, which would give them standing to sue. To my knowledge, even though thousands of legitimate complaints have been filed by these organizations, not a single tax-exempt status has been threatened or revoked. Could it be that the IRS isn't as sure about the constitutionality of the Johnson Amendment as many might think? Rather than getting rid of this bad law, Congress seems to want to tweak around the edges. Well, not the best solution. I think it would be better than what we have now. This legislation is still in progress. Maybe we can even convince our elected representatives to make it better before the final vote. You know, this idea of separation of church and state is so misunderstood that it's been used to silence churches and ministries and charitable organizations for decades. When you read the Johnson Amendment, you'll find it's not quite as restrictive as most people say, but it is still a violation of the First Amendment because you are abridging an individual's right to speak because they're talking about a candidate or a piece of legislation. Why should our elected representatives be exempt from comment simply because they're elected and the person commenting happens to work for a nonprofit? It's a weird situation, but it's not terribly surprising. So far, this legislation has only passed the House of Representatives, so I'll be keeping an eye as it progresses through the rest of Congress, and we'll see what happens. But it's important to understand the basis for this. The very fact that people have tried to get the IRS to question their tax-exempt status for the purpose of suing the IRS should tell you there are some people that are pretty sure they could win a case in federal court, even though it's never happened. This is some of the stuff we work on here at the Constitution Study. If you want to find out more, go to constitutionstudy.com. I've got plenty of articles. I've got my radio episodes. I've got news feeds that I present, my mailing list, the store. There's lots of things you can do there. It also, you can help support the work that we're doing. Go to constitutionstudy.com/shop and pick up a book or a mug or just donate to the cause, either one time or recurring. It's all available right there. I also found this great course that I think you'll like. It's called The Miracle of America. Just go to constitutionstudy.com/1776 study guide. You go to a custom landing page just for my listeners. You can read more about the course and the speaker. Best of all, you can enroll for a lesson absolutely free. That's right. You get an entire lesson on God's natural law, the downloadable study guide, an hour of content, either audio or video, absolutely free. If you like it and you want to take the rest of the course, the whole thing's just $17.76, which I think is a pretty good deal. Another way you can help is by, using your cell phone. Let's stop supporting organizations that are fighting to remove our rights, to restrict our rights. Let's work with companies that are trying to support our rights, like Patriot Mobile, America's only Christian conservative wireless provider. When I joined with them a few years ago, I get great 4G and 5G coverage all across the country on the same networks and same towers that the major carriers use, but when I pay my bill, a portion of it goes to organizations that are protecting our rights. Folds of Honor, Students for Life, supporting veterans and first responders. Not to organizations that are trying to take away our rights. So their customer service is 100% US based. They've been a pleasure to deal with. I haven't had any problems with them whatsoever. And I know that my money's being used for good causes. So join me there at patriotmobile.com/constitution to find a plan that works for you. And be sure to use the code Constitution at checkout to get free activation. Once again, that URL is patriotmobile.com/constitution to find a plan. And don't forget to use the code Constitution at checkout to get free activation. Whatever you do, please take this episode, take the links to all the work that I do, and share it. Let other people know this is out here and encourage them to come join us the next time we get together for the Constitution Study.
Love the neighbors and have a few good friends.